Good evening, everybody. Thank you very much for joining us for this last session, actually, but also for our book launch. And it is a great pleasure for me that I can share this evening session and to discuss with the editors of the book, The Coronavirus and Law, the idea of this book, which was the idea of Professor Hondius, and then how this idea has been implemented, mostly by Marta Santos Silva, and then by us here, Professor Pablo Salvador Code, Professor Andrea Nicolossi, and myself, and with the group, incredible group of our junior editors were helping us in preparing this book, and of course, great number of authors were willing to write the papers in extremely short time, extremely tight time, and everything has been done on time. So it is really, we are very grateful to everybody who have participated in this project. We want to discuss our methodology. We want to discuss how we developed this idea, how we were trying to get diversity, which we have now in our book, why the structure is looks like as it looks like, and what will be the future of the book, because the book is not ready yet. We have only a version which has been published online, which is a kind of dirty version, you can say. It's not entirely ready. And we can also, we would like to discuss the process, how this book is adapted in this very difficult time, with the purpose to have something which can explain to the legal audience the complexity of the COVID-19 legislation in the European countries. So we are starting with the main initiator of this idea, Professor Hondius. Professor Hondius, you have the floor.
Thank you very much, Frederick. And I'm very happy to be here with you on the screen, apparently. Seems very wonderful that this is possible. Now, I would like to say something about the backgrounds of this project. We all know that there are various sources of the law. We have legislation, which for most of us in the civil law countries is the primary source. We do have, of course, also case law, which makes the law much more spicy for our students. We also have the doctrinal works, which give us a fundament for the further development of the law. And perhaps we also have, as a fourth source, the cases and the especially the non-legislative sources. And what we now see is that in the 1990s, for the first time, scholars began to come together on an international level. Before, scholars always have come together, but usually on a very parochial level in member states, with the Germans meeting German colleagues, the English meeting English colleagues, etc. And now for the first time in the 1990s, these became international groups. And we must give honor to somebody who was remembered here in this floor some days ago, Ole Longo, who started the initiative of the principles of European contract law. Various other such efforts have been made. We have the principles of international commercial contracts from UNIDROIT. We have various other groups which started internationally oriented groups. And the question now arose, what to do when the work had been finished. There were various options. One option would be to continue the work with a second edition, or perhaps to continue to work and develop other themes. But there was also a possibility not to do anything, but on the internet, people would remain into contact. And this has happened with especially the people who were involved in the London group and in the DCFR. They came together on the internet. One chief organizer in this area has been Matthias Sturme, who often asked us to convene. What we also did was to send out international information. I recall, for instance, that I informed my colleagues about a case handed down by the Dutch Supreme Court, the so-called Urgenda case, in which the government was ordered to live up to the Paris Treaty on environmental clean health. And many such other efforts were undertaken. And then what happened was early this year, Corona came. And there was a number of people who said, we must do something about it. Let's combine our efforts. There were at least two groups. One group which handed in a paper on social justice. This is the Mitglieds group, which has already done its work. And the other group, which Marta is going to address shortly, is our group. And I think it's very useful for us to learn from the comments by you, but also it might be useful for you to learn of the experiences which we have had with our group. And if the chair allows me, I would like to hand over the speaking easel to Marta. Thank you.
Thank you. Thank you very much. Of course, I'm quite terrible chair, because at the beginning I have forgot to mention one of the most important person in our panel here, Christiane Wenderhorst, who was of course the editor of the book, and he's not only the host of the conference and the most important person of the conference, but she played absolutely pivotal role in editing process of our project. Okay, but now we are coming to the person who actually has done the most of work of our group, and Marta Santos Silva. She was exactly the person who organized the whole work on not only of the editing board, but also of our younger staff. It is her idea how this book has been actually developed, and therefore she is awarded as initiator, and she is the main editor of this project. Marta, you have the floor.
Thank you very much, Friedrich. I will just start sharing my presentation. So dear chair, dear colleagues, dear ladies and gentlemen, I would like to start this very short presentation by thanking the ELI for the distinct honor of presenting in a panel of its very special 2020 annual conference, and doing so with such an internationally respected group of scholars with whom I had the honor and the pleasure of working closely with for the last 4 months. The online version of the edited book project, Coronavirus and the Law in Europe, was published in open access with Intersentia Online 3 weeks ago, and I was asked to briefly present the methodology we used. The reason for this request was the understanding shared by everyone in the backstage of this project that the methodology was one of the main pillars that supported the development and implementation of this project. But before dwelling into the methodology, a few additional notes on the background that Ehud already presented so well. The book project, Coronavirus and the Law, was born from a spontaneous but brilliant idea of Ehud, as you have understood, of putting together a liber amicorum. As he put it, and I quote, A Festschrift sounded too festive for the occasion, and a Gedächtnisschrift sounded too gloomy. The title Ode an die Freude was suggested, which merely for editorial reasons ended up by having the less picturesque but perhaps a bit more intuitive title of Coronavirus and the Law in Europe. The idea was received with much enthusiasm by its recipients, colleagues and friends from different European private law projects all around Europe that occasionally keep in touch to disseminate academic developments and ideas, and also to exchange friendly greetings and celebratory occasions. There was great support to Ewood's ideas, so we invited 5 jurists coming from Austria, Poland, Italy, Spain, and Portugal to take up the editorship of the book. The project kickstart was in April. The editorial board met on a weekly basis ever since, and given the restrictions imposed by Corona, it did so exclusively via the platform where we are all gathered tonight. Initially, Ewood envisaged our project as an open access online book only. However, given the unexpectedly strong adherence to the project, we decided to project a print version of the book as well. The project was thus conceived as a 2-step project. We would start with an ebook and then proceed with the traditional paperback version. For the purpose of implementing the book project, we contacted the international publisher Intersensia, and timely so, as it was just in the launching stage of the innovative Intersensia online database that purports to publish up-to-date and updatable, topical and quality-reviewed legal content. Use of the platform is intuitive. Users can use it in a way that is convenient for their needs. A national judge may wish to type ECJ and be then directed to all legal contents where the European Court's case law has been cited. A national reporter involved in comparative research may type the name of a country and have access to all the texts where the law in that same country is analyzed or mentioned. It was agreed with Intersensia that there will be an ebook, and that such ebook would remain available in open access for a limited period of time, so as to allow judges, practitioners, academics, and citizens to have quick answers to their pressing legal questions. It was also agreed that the ebook would be followed by a print version to be out sometime in early spring 2021. The idea of this book was to serve, as my colleague Pablo Salvador Coderc so eloquently put it, as an atlas of the law in Europe. Most of those that signed up for this endeavor were from the field of private law, so we invited a few scholars from public law to contribute to our book project. Publishing a book may involve some costs at some time, and 2 Spanish funding bodies generously offer to support us financially if and when such costs need to be incurred. It's important to mention that although we sent out some drafting guidelines, we have opted for giving full freedom to the authors to write from the perspective they found more interesting and more appropriate. We did not pre-assign research questions in advance that authors should work on. We opted for remaining open to the topics suggested by the authors, also in light of the fact that we wish to publish as soon as possible. Now, what you may find here is probably the slide of this presentation that makes more justice to the spirit that ran throughout this initiative. This is a screenshot that was taken in the very first meeting that I, as coordinator, had with our team of 11 assistants, young scholars that voluntarily signed up to pledge their summers for helping make this project possible. Despite the diversity of geographic and academic backgrounds, there was an unexpected harmony between the team members. They took upon difficult tasks, such as the detailed compliance check with style guidelines, the correction of typos, and the occasional recommendation of changes to the text itself. They did so in troubling times, and despite their other academic and personal commitments, and for that myself and the editorial board are extremely grateful. Having worked with them closely, I may say we have reasons to be hopeful about the very next generation of academics, whose dedication and professionalism truly striked me. Now, we have been contacted by colleagues from some academic institutions that wish to know how we coordinate such a large team exclusively online during the busy end of the academic year and mainly during Corona-imposed lockdowns. In the automated jargon, I must be considered an hybrid. I originally come from a Southern European country that coined the Platonic term of Soldat, but I lived and worked in Germany for many years. So the BGB-like, highly structured and compartmentalized organization with which my fellow co-editors patiently agreed helped, I believe, to make things work. We kept online shared folders for the contributions received, the contributions assigned to proofreaders, the contributions that were edited and formatted, and the ones that we uploaded to Intersensia online. We did not exchange email attachments. To our knowledge, in these 4 intense months, no document was lost or corrupted in the process. Our time press journey was made out of 11 steps. Some contributions were received by the original deadline of the 15th of June. Some contributions were received a little later. In any case, I must say how impressed we were by the cooperation of our authors that agreed to make often multiple small changes during their annual leaves. The devil is in the details, and it's certainly so when the readers of a contribution come from a different legal background. The internal peer review process was detailed, and it often led to 3 requests for amendments, for which authors were sometimes given as few as 48 hours to respond. We have also been impressed by the external peer reviewers, most of which have already sent their filled-in peer review forms for the print publication. These academics, the top in their field, were given a short time to read and comment on the book chapters and have not only complied with a strict deadline, but also often sent us a very detailed commentary of the papers, which will start being processed by the authors as early as next week. Last but certainly not least, I was truly struck and sometimes even touched by the incredible vision, guidance, and dedication of my very distinct fellow co-editors, who often undermine their holidays in Sardinia, Istrian coast, East and South Tyrol to review contributions or take important decisions concerning the development of the project. As the youngest and least experienced academic in the group, I feel humbled and extraordinarily grateful for having had the chance of working with all of them. So, dear colleagues, the final result is online and it's open accessible to all. It contains 57 individual or co-author chapters that represent at least 17 European countries. The book has been divided in 7 parts. In that, which was one of the most complex and time-consuming exercises the editorial board had to undertake. As said, we had no previous agenda about the topics which should be covered in the book, and we needed to deal with the contributions as we received them. We opted for dividing the book in 7 parts, and these were essentially based on the concrete content of each chapter, and not only on the country covered, for example. So if you access the bundle and you click in Preface, not only you will have access to the wonderful introduction to the volume written by the distinct initiator of this project, Evert Hondius, but you would also have an overview on the left of the remaining parts of the book. If, for example, you are a member of the online intermediary platform subgroup of the Digital Law CIG, or simply if you wish to know if you are entitled to a refund from Airbnb for an apartment which you could not use because of Corona restrictions, you may type digital platforms in the main Intersensia page and then be directed to this page, where you will see not only which contributions discuss this in our book, but also from which legal perspective, as you may see on the bottom left corner. All of this was made possible due to the innovative, out-of-the-box thinking of Intersensia, the input of our contributors, and the many hours of work by our assistants who manually inserted the relevant metadata into the platform. As for the next steps, the external peer review process is ongoing and the print publication is in preparation. Until early spring 2021, the process should be completed. Perhaps there will be a bigger project if there are enough resources, mainly time and funds. I certainly believe that it would be extraordinary to continue, by this group or by others, the foundations that have been laid for the comparative research in this new legal field of Corona studies. Thank you very much for your attention.
Thank you very much, Marta, for this excellent presentation. And now you can understand how everything was possible in this short time, and the way how Marta was working and organizing everything and structuring everything. We have seen exactly the way how it has happened and how it was possible, and what was really the moving force to get it possible. So we are extremely thankful for this and for this whole work. Yes, so now we are going further. Professor Nicolucci, and please, you have a floor for your.
Thank you for the floor. And I greet all those present, obviously only online present, unfortunately, and I will say just a few words to underline the meaning I attribute to this book that has spontaneously united so many European jurists. Ever since the proposal of the book was made by Ewood, who was the inspirer of the work, whom I publicly thank for involving me, it was clear that the challenge was to show the spirit of cooperation among European jurists in such a delicate moment. The extraordinary and surprising way in which more than 80 colleagues have offered their contribution in a very short time has shown that the intuition was right. The result, to use a beautiful image by Pablo, is an atlas of how the different jurisdictions are dealing with the problems of the pandemic. Each author has provided a piece, and the whole has become a mosaic that is offered for subsequent more meditated reflections, hopefully with detachment from the pressure of the pandemic. In recent months, there has been talk of European solidarity and of the idea that a small but great continent like ours should not lose the sense of union, at least in the most difficult moments, and with regard to issues concerning fundamental values that European culture has been able to recognize. Certainly, a protection of every person's health is among the fundamental rights. However, in my opinion, solidarity implies a sense of responsibility, because it is right that those who ask for solidarity show in turn that they know how to be responsible. Aristotle speaks not only of distributive justice, but also of commutative justice. I think that in the volume this idea is in a certain way summarized in the part on contracts. The pandemic has affected certain contractual relationships in a way in which one of the two parties could only suffer damage and the other benefit from it. It is not a fair solution, obviously, and in one way or another, in different countries, this issue has been debated and has also found legislative solutions. In Germany, the law accepted the category of essential long-term contracts, about which I had the pleasure to write some time ago with a few colleagues and friends. I do not judge whether it is technically the right solution for the German legal system. I limit myself to saying that this category basically expresses a criterion of fairness. In fact, especially when there is an essential need at stake, the negative consequences of extraordinary events should not fall only on the weaker party, but at least be borne by both parties. This can be the metaphor of the concept of Europe, under which countries and people share the difficulties with a view to improving the good of all. Last but not least, let me thank, as Frederick did, let me thank Marta, who was and is an excellent coordinator. And also I want to thank Christiane, Pablo, and Frederick. We worked very well together, and I learned a lot from each of them. Thank you.
Thank you very much for these kind words. And now, Pablo, you have Pablo Salvador Coder. You have a floor.
Thank you very much, Frederick. Thank you. When a couple of months ago, Edward Hondius asked me to join an editorial board engaged in the task of publishing a book whose title would be more or less Coronavirus Underline Europe, I immediately accepted. Edward Hondius is able and has been able to blend three generations of legal scholars. This is mine, he and me, then Frederick's, Christian's, and Andrea, and then Marta's. So three generations of European scholars are present here in order to answer to the questions raised by coronavirus in Europe, in European law, in national law. He mentioned Orlando, and I have to start recalling Orlando's legacy. The Landos migrated to Denmark during the First World War. They then saved their lives thanks to the courage, to the incredible courage of the Danish nation in October '43. And from the ruins of Second World War emerged a gigantic international business lawyer, academic lawyer. In the 80s, he started the Commission on European Contract Law. As Edward, as Christian Fumar, as many others, as Hugh Bill, we joined the Commission, and we tried very much to build a kind of, say, principles, restatement, European code. We were perhaps wrong or not quite right, but we did it. And the principles are one of the bases of our law of the contracts in academic meaning of the word. As other members of the Commission, I always had some doubts in those times of widening and deepening of the European Union. I always thought that the French Civil Code, many decades older than the Constitution, the French Constitution, the German Civil Code, many decades older than the German Constitution, were there to stay. And we finally arrived to the conclusion that we should go on and on working on the European law of contracts, but respecting traditional cultures, national cultures, and national diversity, because there has always been a couple of models in the harmonization of law. There is one way, top down, build a model, a project model of one code and take it as given. And the other one is competition. We have a lot of national systems, we have a subsidiary systems, and we, the economic agents, can choose. The tension between those two models is here to stay. And when we were thinking about what the future was, coronavirus came, corona came. The pandemic affected strongly the national legal systems, and my own system built in a couple of months an emergency law, and we instantly thought that conservation of contracts should be compatible with adjustment of contracts, in our case with consumer contracts, under the good faith principle. I think we're achieving this result, but we are not finding a solution, an agreed solution to the main question raised by Lando's tradition. Are we traveling to a European civil code, or are we respecting our national systems? What will happen after the pandemic? What will happen after the vaccines have reached 400 million of Europeans? I think that the discussion will be there, that the debate will be there. And I'm one of the academics who thinks that competition is a very good idea. So having a competition among different systems is perhaps our main goal. And this book, Coronavirus and the Law, will help us to see how different countries in Europe, how 17 different countries have answered to the challenge raised by coronavirus to the principle of conservation of contracts. Our own answer in Spain has been coronavirus is challenging the law of contracts, but good faith reclamation, good faith claims are okay. What we are not doing is destroying pacta sunt servanda, destroying the principle of conservation of contracts. I should thank Ebert Hondius for blending three generations of scholars. I should thank very expressively Marta Santos for being the general manager of this editorial project, Christian Bendehorst for being the spirit of the European Law Institute and the main glue of this project, and Andrea and Friedrich for being so good academics. Thank you to you all. We will follow looking for solutions in this task without an end of having or not having a European law of contracts competing between them. Thank you.
Thank you very much for this great speech. And for everybody in the audience, we have, of course, our questions and answers questionnaire. So if you would like to join our discussion here, also everybody is warmly invited to do so. I would like also a little bit as a chair, I don't want to take the floor for too long, but I wanted just to also to stress maybe two aspects of this book, which I think are extraordinary in certain sense. It is a little bit because of the pressure of time that we wanted to identify the issues which are in Europe caused by the coronavirus crisis. And therefore, it was not our task, or it was not we didn't want just to formulate a question, a very precise question about the reaction of the legal systems of European countries, of the European Union, and going beyond of the European Union. But we wanted also to see what lawyers from these countries are going or want to say us about the coronavirus. So therefore, our topic was formulated in a very general terms, because it was the interesting exercise to see what kind of questions also these different legal systems would formulate. So it was not, we are not looking for specific questions from our perspective, but we wanted to see what kind of questions are formulated, are discussed by different in different countries, in different systems. And I think for this reason, this book is successful, that we can see with very different methods, with very different approaches, what really was battering the people, was a problem for so many jurisdictions. And there are very different problems, and there are very different issues, which you can see from this book. The picture is not complete, of course, but I think this is a picture which forces us also to think about the comparative method, about the outcome, how people not being asked on particular issue are answering to and providing a picture. And this is also quite interesting. Another point. 1 year ago, I took part in a very interesting conference in a very beautiful place in Slovakian Smolenice, which is one I have to say, one of the most beautiful places for conferences, small places for conferences, beautiful castle. And where it was, the subject of this conference was ad hoc legislation. And nobody was thinking at this time, it was September of last year, beautiful September, nobody was really thinking that something is coming to us, on us, coronavirus crisis. And it will be exactly the time of this ad hoc legislation everywhere. But incredible laws has been adopted, bylaws or different decisions, and we will be confronted with diversity of the reaction of the states on the coronavirus crisis. And this book is reflecting this very different development. And also it's a kind of test to which purposes this coronavirus has been also used by some member states. We will see also some very problematic signals, warning signals from countries where the states were not only reacting against the coronavirus, but sometimes were more focused on integrating the power or somehow redistributing the structure of the power of the state. So it was also a fascinating field of research, and you may find everything in this book, or you may find the traces in this book. We have also added to this book our ELI principles on coronavirus. And there is no explanation, further explanation given, and we don't want to provide further explanation. It is a little bit to do a challenge for readers. They have to do it on their own, to look how far, what is really the role of our principles of the ELI in relation to all these different legal developments which we are facing in European countries. And I think it may prove, if of course, it must be probably the work of the readers to come to the different results. But I think it may prove how important our ELI principles are. How many difficulties, and if you are looking on these principles and looking on these answers coming from different states, it is great material to think about the development and to think about it. What will be our world after the crisis, after the pandemic will go to its end? So I think this book will be an important input into the discussion how our systems will look like after the crisis. what kind of remainings of what has happened actually to all our systems, and this extraordinary situations. There are also decisive moments for the development, for further development of the private law. And we can see on it already how many legal institutions, legal concepts have been developed exactly at this time. So thank you very much. And now we are starting, if I may, Cristiano, of course, will have a floor, but firstly, we want to discuss with our audience. So please, if you are interested in our discussion and if you have questions, please do it. Now, I have a question of Clara Fahrleitner. Is the book intended for students, scholars, legal professionals, and the general public, or can it also be regarded as a potential tool for politicians and future political, legal, and social developments concerning the COVID-19 regulations, just like the ELI principles? Additionally, I have a question for Frederick Zoll. In your opinion, which in particular is the most crucial lesson learned from the crisis according to your research? Okay. So I think the first question, I think Marta can answer in the best way. So you are still.
I would say that actually I'm the least capable of answering this question. I would perhaps invite.
Yeah, sorry.
I would perhaps invite Ewood to answer it, or Andrea, Pablo, Friedrich, yourself, or Christian, perhaps. Otherwise, I'm happy to answer it myself.
I think you have to. I think it will be the best way.
Well, we're just passing on the hot potato. No, I would just say that the idea, like I tried to explain, was to have indeed a toolbox to be used by whoever needs it. And these would be, of course, and we thought about initially mainly academics and practitioners, judges that will need to know how a certain situation has been dealt with in other European countries. This might indeed be used by politicians and future politicians. So this is, well, for sure, it's going to be a source of inspiration. This has been a systematized attempt of putting this knowledge together, of developing things anew. The knowledge was not there mostly. And so this is indeed a toolbox that may be used by several, or in for several situations and by several people. So I'm not sure if I answered correctly and thoroughly your question, but I would say that we are very open and we hope that this knowledge can serve whoever needs it.
Well, if I can,
oh, yeah.
if I can have a word, there have been in Europe many different strategies from the medical point of view to challenge coronavirus. And this book is thought as a toolbox, as a repository of experiences, European experiences of national legal systems, in order to answer to the questions raised by coronavirus. And coronavirus is here to stay for at least 1 more year, perhaps 2 years. And so national governments, politicians, legislators, academics can make use of this book in order to compare how in 17 different countries general answers have been given, but also nuanced and specialized answers have been given, and perhaps we have added a repository of experience to the next future, for the next future.